Hi everybody, and thank you for attending today. I've just been invited to very briefly talk about the Retail Shop Leases Act 1994 and the amendments that were made. So let's get into it. The Retail Shop Leases Act 1994 has undergone a number of long-awaited amendments authorised through the Queensland Parliament as a result of a statutory review of the Act that was carried out in 2015. Consequently, the Retail Shop Leases Amendment Act 2016 was enacted in May 2016, as I'm sure everybody's aware. Now, I was just invited here today to briefly talk about the advantages and disadvantages that this will impose upon landlords and tenants, our clients for the company here. So the amendments impact both landlords and tenants involved in retail shop leasing in Queensland. While the legislation still upholds the fundamental consumer protectionist principles that the original Act was established on, the legislative overhaul introduced changes in relation to a number of issues, such as what tenancies are covered by the Act, disclosure requirements, turnover statements, landlords' outgoings, as well as compensation provisions. The Reformed Act proposes a number of advantages in relation to lessors, including considerably easing red tape and enhancing protections. A quick, adventurous summary of the legislative overhaul includes an easement of what is covered as a lease under the law, with numerous things, one of being that tenancies of large premises greater than 1,000 metre squares are now excluded from the Act's requirements, which was not the case beforehand. The Act also improves and clarifies pre-lease disclosure requirements, as well as compensation provisions. The amendments include simplified and updated compensation requirements, such as authorising a provision in a lease that limits a tenant's right to claim compensation from the landlord for certain disturbances to the tenant's business. If the conditions are satisfied, this will be beneficial to landlords and is likely to lessen the risk of losses and compensating to tenants, so they save more money in the long run. In relation to liability of costs, a benefit is that the Act requires a prospective tenant to pay the landlord's reasonable and invoiced legal expenses of preparing the tenant's lease, provided that the tenant has given the landlord a written notice to prepare the final lease. And lastly, a benefit for both parties is that the previous provisions regarding trading hours were updated, which now provide that a tenant trading outside the core hours of the shopping centre is no longer void. This is a key income advantage for both the lessor and the lessee. So, however, lessors may feel that some of the modifications are disadvantaging to them. Some key changes that may be considered as such are requirements relating to refurbishment and refitting, in that a lease where a lessor has required the tenant to refurbish or refit is now void unless the details are specified in the lease. So moreover, the liability for costs associated with the lease costs were also amended to make the landlord responsible for paying the legal and other expenses of obtaining their mortgagee's consent and for the landlord's compliance with the Act. So that's another disadvantage that they may feel. As a result, however, all of these changes, they're all very important, and it's very important as a company that the retail tenancy documents within the company are reviewed to identify whether an update is required to abide by the legislative changes enforced. It is significant that the company take the time to ensure that both landlords and tenants are familiarised with the array of modifications for future reference. In particular relation to lessors, it is significant that the amendments are understood to avoid any breaches or unlawful performances under the Innovative Act. So that concludes my short summary of the involved changes to the Retail Shop Leases Amendment Act 2016. I thank you all very much for your time.